Mufesi and 15 others.
Mr. Donation. Thank you. Yes.
Perhaps if I may, from scope for procedure for accused number 60, I have not appeared before the Lord in this matter before. Mr. Kramer,
Yes, I see that's what the record reflects. Thank you. And the legal representatives of all the other accused are as on the previous appearance. Mr. Papier, you're still here for accused number 1, Mr. Zabugo for number 2, Lewis for number 3, and 4. I see, oh, it's not Mr. Hodes, 3 and 4. Okay. And 13, yes. Okay, Mr. Jagan, Mr. Mansa, Mr. Maroka for 7 and 8. Mr. Jorgensen, Mr. Mazubugo again for 12, and Mr. Potgieter for number 14, Mr. Ngase for number 15. That is still the position. Thank you. Yes, Mr. Donation?
This is your wish, my lord. Before Mr. Donation can address you, my lord, I wish to place myself on record in respect of accused number 9
and 10. Mr. Mutloung from Legal Aid South Africa then for 9 and 10. Thank you, Mr. Mutloung.
As the court pleases, my lord, I am Kopano Mokolo from the legal bar. I'm appealing on behalf of accused number 7, Mr. Ketfano.
Oh. Only 7 or 7 and 8?
My lord, accused number 8 has since been liquidated. I've just given the same information to my lineage friend with that.
Thank you. Mr. Hodes, I was informed at 9:30 this morning that you would be 5 minutes late. And 15 minutes thereafter, I was informed that you are somewhere in the building. You just arrived, and I then had to wait another 5 minutes for you. What was the reason for you coming late to court?
Well, I apologize. From the time we got here, we get through the roadblocks and had to park the other side and walk across, which of course the delay. And then there were the security issues. We apologize profusely, my lord. It's not myself, my attorneys, both attorneys and my junior. I apologize for that, my lord. It will not occur again.
Please, Mr. Hodes, this court starts at 9:30.
As a lordship.
Thank you. Apology
Thank you,
accepted.
Thank you.
Yes, Mr. Donation.
Thank you, my lord. My lord, I think we should address the whole section 212 capital B issue.
Yes.
I received replies on the following accused: accused 6, accused 9, accused 15, and accused 16. From accused 13, I received a notice in terms of Section 85 of the Criminal Procedure Act, a complaint basically against the inclusion of contravention of Section 34 of the corruption legislation. That is the only feedback that I got pertaining to the Section 200 clause.
Yes. Only accused number 15's reply was filed by Mr. Diteko in the file, so I accept what you're saying, that accused 6, 9, and 16 also filed. Mr. Papier, what is the situation?
Your worship,
we did not have sufficient time to consult in order to prepare the response to the notice, but I can confirm that we will follow the response to the notice before the next appearance, or whatever that you direct us to file the response.
Did you now have the opportunity to consult with your
I
client?
did have the opportunity.
Mr. Mazibugo?
Mr. Postponement, on behalf of both accused number 2 and number 12, I have informed my colleague for the state that they do not take issue with matters set out in the section 212B notice set on them by the state.
So therefore you are saying that the deeming provision may kick in with regard to them?
May kick in with regards to both.
Thanks.
Well,
Thank you, sir. Mr. Houders?
Lord, we've had insufficient time to take full instructions. We have canvassed it as a team, and we will be sending a written response within a period of a week, my Lord. I can commit to that.
Thank you.
I'm going to wait for my other accused in due course, my Lord, so it follows the sequence of the charge sheet. But that's on behalf of accused 3 and 4 now.
3 and 4, okay.
Yes, my Lord.
Or in respect of accused number 13, there's another issue that arises, obviously.
Number 13 never
Yeah.
We'll
Okay.
wait for that.
You're right, thank you. Mr. Jagan?
Well, look, I only received it this morning. There's an issue, transmission of the 212. The email address used is the alphabets were inverse. However, I have received it this morning.
This morning. So you also need time?
I also need time, my lord.
Thank you. Mr. Mansa?
Excuse the court, my lord, we did submit on behalf of accused number 6.
Number 6, yes. Mr. Mhlongo, what's the position with 7 and, only 7, because you say 8 has been liquidated?
My lord, I would request some time in order to consult thoroughly on the matter. I've only been briefed last week, my lord. The court is-
Mr. Mhlongo?
As the court pleases, my lord, I confirm that the reply was indeed submitted to my learned colleague on behalf of the state, and thus the accused number 9 is in compliance
And number
with
10?
the notice received.
And accused number 10?
It's on behalf of both accused
Both of
number
them.
9 and 10.
And 10.
As the court pleases, my lord.
Mr. Donation, you confirm that? Because you only said that with regard to number 9. Is it 9 and 10 then?
We'll just bear with me. a
Yes.
second.
Okay.
Yes, indeed, my Lord. It refers to both accused.
Thank you. Mr. Jorgensen?
As the Lord pleases, we require some more time to consult, but the response can be forthcoming within the next 14 days. As the Lord pleases.
Mr. Mazibugo for number 12?
The position is the same.
The same there. You said 2 and 12, right? Yes. Thank you. Mr. Houders,
My Lord,
can I leave the situation of accused number 13 for now,
Yes,
and then just give you time because you have filed a 85 notice?
yes, my Lord.
Thank you. Can we then, Mr.
My Lord, that
Potgieter?
85 notice is not for accused number 13.
It's not put number 13.
No, my Lord.
Well, that's what Mr. Donation said. Okay.
No, I apologize, my Lord. That is the case.
This is the case with
Yes,
the,
my Lord.
okay, fine. Mr. Potgieter?
I please quote my lord. I confirm that we only received the section 212B yesterday, we noticed that there was a problem insofar as the email address of my instructing attorney. However, we are now in possession of it. I have taken short instructions on it, and a reply will be forthcoming in the next meeting.
Mr. Nkhahle.
My lord, the notice on behalf of accused number 15 was even filed in the court file.
Yeah. And Mr. Kramer? Oh, Mr. Calvin, sorry.
Yes.
We've
complied, my lord. We have not filed formally as yet in your lordship's file. We'll see
Yes.
to it today. There was also a problem with the email address, but once we receive it, we considered it answered, and we'll see to proper filing today.
Thank you.
Thank you.
Yes, Mr. Houders.
Lord, I need to commence with an apology. I confused my two clients in relation to accused 3 and 4, my lord. We never received the notice.
You did not receive a notice
No, my lord.
at
My
all.
attorney is present in court. His name is Mr. Jerome Levitt of the firm Flaxman. No notice was received. I knew about it from my other client, my lord. That's why I told him about it. But he assures me, and he checked his emails as recently as this morning, and he assures me that he never received the notification. Nevertheless, my lord, I can bind myself to responding, as I said earlier, my lord, within 14 days in that regard.
Yes.
I have no difficulty.
Okay.
My lord, in relation to accused number 13, you filed a section 85 notification contending that there's a fundamental error in the charge, and that we're objecting to the charge, and because it doesn't come, he doesn't fall within the definition of the Prevention and Combating of Corruption Activities Act 12 of 2004, referred to as PRECA, my lord, because it has a specific class of persons that it refers to, and that accused number 13, Mr. Magashule, does not fall within that class of persons. It would be irregular in our submission. That's why we've filed the notice for him to be charged. We've additionally asked, I know because it's a very complicated docket and indictment, as your lordship would be aware, not of the docket but of the indictment, my lord. So we've asked which people implicating. The state isn't prepared to commit themselves to which people. They've told us to read the entire docket, but be that as it may, we believe that there's an irregularity in the charge, and we want to pursue an objection to the charge in that regard. We've set it out in the notification. It was only served on my learner friend this morning, so it would be unfair to expect him to answer immediately unless he's in a position to do so. But I believe that's one of the pre-trial issues that can be dealt with prior to the trial commencing. We say it would be improper to charge him with the contravention of PRECA.
In terms of the section 212 capital B note served on you with regard to accused number 13, it seems to me that in as far as there are charges which relate to him, there are indeed persons mentioned in those charges, or a person at least, that implicates him. And when you say persons implicating him, what do you mean?
We had asked the state to identify which state witnesses implicate him, and they have told us to refer to the docket and the indictment to determine that they're not prepared to commit themselves to naming particular individuals. Of course,
by the individual mentioned in the 212 capital B statement.
In relation to the 212B, my lord, that's where we need time still to formulate our response to it. We will not be making all of the admissions, my lord. Some of them are questions of law. Some of them are way beyond his knowledge. So it would be foolhardy to expect us to admit all of the admissions sought. I think it's quite normal that they ask for them, but there's some that are just totally beyond his knowledge and impossible.
No, I accept that, but it is in any case the practice that you admit what you can admit. Yes. What you can't admit, you just state that you deny it, or it is not within your knowledge.
Absolutely. That's in the process of formulating, my lord.
Yes.
As I said, that's why I had confused the numbering And I said that we could commit to answering it within a week. We're in a position to do so. We have drafted the response, but it hasn't been finalized in the short time available.
Thank you. Mr. Denason, let's first deal with the issue of the witnesses implicating accused number 13. Why are you not prepared to give a list of witnesses which implicates accused number 13?
My Lord, I think we can revisit that issue closer to this trial. It's very difficult for me to now stand and recite a list of witnesses directly implicating X, Y, or Z.
But you ought to know your docket at this stage and know who implicates who. I think what Mr. Hodis is asking, just a list of the names implicating accused number 13. I don't think he wants a summary of what they will be saying, because your 212 capital B request is quite comprehensive, I must say.
Indeed.
So is there any objection to giving him the list of witnesses that implicate accused number 13? Or do you want to argue it at some future stage?
I'll argue it at some stage. I think it's quite logic that they will have to read the whole docket, unfortunately.
Yes.
So, and I don't want to bind myself to 5 or 10 witnesses.
But you do not have to. You can, for instance, say they include the following, and I reserve the right to call more if needs be.
Yes. I'll consider it, my Lord.
Please do.
Yes.
All right. And then in terms of the notice that was served on you by accused number 13?
As stated, I received it this morning.
Okay.
As in 10 to 10. I will peruse it, study it, and compile the necessary response in as soon as possible. Then, my Lord, pertaining to the notices, it was the notice, every one of it was sent by email.
Yes.
By one of our clerks. Mr. Pranav indicated to me that we had his email address wrong. He gave me an alternative one. Just strange enough that this email went through.
Which one?
The one that we sent on the 5th of October.
Okay. But to the wrong email address.
Well, we don't know where to. But
okay. But okay, fine.
The same with Mr. Levitt.
Okay.
So, yeah, that's the only two that apparently has a problem. The rest received theirs. Yes.
But I think for today's purposes, every one of the legal representatives received your notice.
Indeed, my Lord, and it was all sent, apart from those two, it was all sent on the 5th of October, officially. As a president. So,
because most or some of them did not have sufficient time to comply with the provisions of Section 212 capital B, we will have to postpone the matter. I think Mr. Hodis asked for 2 weeks within which to comply.
I said 1 week, but we have
1 week.
2 weeks. And
oh, then it must be Mr. Potgieter who asked for 2 weeks.
2 weeks, yeah.
Yes.
2 weeks would be
2 weeks, yeah. I think that would be the outer limit, and in order to manage these proceedings. Can you give me a date, Mr. Denason? And then we can find out from the legal representatives, preferably a Wednesday. I'll tell you why. Because Tuesdays are normally our trial dates, and there are a lot of other litigants and legal representatives that need to enter the building, and with all these security measures, they find it a bit impractical to enter the building on time. So Wednesdays is a safer bet.
My Lord, I am available on the 3rd of November, and thereafter only on the 24th. Except if my colleague stands in for me.
I think the sooner the better. The 3rd of November, any objection?
My Lord, I can't be on the 3rd, I could be on the 24th. I can print
That takes us way beyond the 2 weeks, Mr. Otis. Okay, and then the Monday of that week, or what day in that week will you be able to attend court?
I would have to send it to you, my lord.
Will you do that? Fine. Thank you.
My lord, I should just place it on record, my lord. On that date, I'm not available, but I'm available on any date that week, my lord. Or the following week, the 10th.
And there's no possibility of you asking your attorney to appear? Does your attorney have right of appearance?
My attorney doesn't have.
Doesn't have right of appearance.
Conference.
Who else is not available on the 3rd?
My lord, I'm not available, but I'll see to it that there's an appearance in Bloemfontein.
Thank you, Mrs. Pascal.
My lord, I'm also not available on the 3rd, but I can make a plan for someone to stand in.
Thank you, Mr.
My lord, I'm also not available on that.
Will you also make a plan?
Yes.
Thank you.
My lord, I have the same problem, but I will also make
Good
arrangements.
Thank you.
My lord, I just want to get clarity.
Yes.
Whether the case is only postponed for the purposes of 212B. And if that is the case, is that applicable also to the accused who have complied? So I'm saying this, my lord, that if the accused who have complied are coming back on the 3rd of November, just for the purposes of those who didn't comply, to file their 212 capital bail, I think it's a little bit unfair to those who have complied to come back under such a circumstance. If it's possible, my lord, we can probably have that day for those accused who did not comply, and another day for all the accused to come, if that pleases the court. That's just my suggestion.
But are you available on the 3rd? That was my question.
I have a trial here, my lord.
Oh, you have a trial, so you're
Yes.
available. Okay. Mr. Donation, there is a sensible suggestion, I think, that I would like to hear your views on, that those who have complied should not appear on the 3rd of November, if we settle on that date, that we should have another date for them. The problem that I foresee, obviously, is there is still not a trial date. If there was a trial date, it would have been no problem to consider the suggestion favorably.
Indeed.
But I would like to hear your views on it, because the obvious question that arises, to what date do we postpone the case against those who have complied?
Yes, that's the first problem, my lord. And the second problem is no accused, in my view, even with a pre-trial, should be without some form of representation. If the counsel can't be here, I haven't got a problem with that, but at least an attorney, so that if there's a question by
No, but he
someone-
says he is here, he is in the building on the day, and therefore arrangements can be made for him to be present and to represent his clients properly.
Then that's
It's
fine.
just the practical thing of having his client come to court on that day, only for the matter to be postponed, or for them to sit and listen whether the others have complied with the section 212 capital B notices. But unfortunately, it would mean that there must be 2 dates. If there was a trial date already, it would be no problem. That practicality would be addressed by them coming back on the trial date and the others coming back for the pre-trial.
As a police court, I am in agreement, Your Lordship.
Any other submissions by any counsel with regard to the request? Nothing. So we are now left with you. It seems like you are the only counsel that is not available on the 3rd, and you also indicated that you would need time to comply.
Yes, my lord. My lord, I should just
Is it? Yes?
I have briefly consulted my lord.
Mm.
However, I needed some time to thoroughly consult for purposes of compiling the report, given its significance, my lord. However, my lord, I can undertake to the honourable court that in any date that the court would deem fit, I'll be able to comply as I have partially consulted.
May I make a suggestion? That you do comply with the section 212 capital B request, which you would then serve on the state and file a copy in the court file. Simultaneously therewith, you may want to file a request that the court excuse you from appearance on that date. But in the event that the trial date is arranged, it will definitely be arranged with you. Will that be fine?
That would be normal.
Thank you.
That's the
Yes, the matter is then postponed for pre-trial to the 3rd of November. All the natural persons' bail is extended and they are warned to appear in this court again at 9 o'clock in the morning. Mr. Otis, 9:30 is when the court starts.
Thank you, my lord.
Thank
I
you.
won't be here, but, junior will-
Yes, please inform your junior then. Thank you. The court adjourns.
Madam, eet jy stempel hier? Kan ek sien een keer op die werk gesit? Rustig. Kom cheers mater, dis geself hier. Ek vind net nie vir jou moeite dis. Nee, maar ek dink ag, ek is nou so voorsigtig na my prokureur gearresteer is nadat hy vir Brendan gevra het vir iets. Ek het sommer net 3 keer